Hi, hello, welcome to my channel Law Made Simple with me Vidya Reddy. Coming to the next part 2 of the interpretation of statutes. In the previous part, we have studied about the interpretation, what is interpretation about and what is statute. Interpretation is nothing but reading and understanding, and construction is conclusion of the interpretation of a statute. So, in this part 2, we will study about the principles of interpretation. What are the fundamental principles involved in the interpreting a statute by the court? The court has the right, the court has the onus of right in implementing the statute which is given by the legislature. So, we have the fundamental first principle of statutory interpretation is that words of a statute must be read in their entire context and in their grammatical and ordinary sense harmoniously with the scheme of the act, the object of the act, and the intention of the legislature. What is the legislature intended in enacting that act is the main preference of the statute, and that should be interpreted by the court. So, what is given by the legislature should only be implemented. So, the second important principle is that the statute should be interpreted in such a manner so as to make it effective and workable rather than to make it ineffective and inoperative. So, why the legislature is making statutes? To operate it, right? So, the court has to interpret in such a manner to operate and make it effective rather than making ineffective. And the third important concept of interpretation is the meaning of the particular term or a phrase in the statute is plain. Effect must be given to it irrespective of its consequences. So, if the statute is plain itself, then no need to worry about the consequences arising. Only implement the statute as it is. So, the purpose of interpretation of the statutes is to help the judge to ascertain the intention of the legislature and not to control any intention or confine within its limits. There are certain rules which are on the basis of which the court should be interpreted these statutes. So, these court of law is not expected to interpret arbitrarily. So, only we have certain rules that court should follow and interpret certain statutes in such a manner to implement it effectively and in an orderly manner. So, let us find what are those rules. The rule of literal or grammatical interpretation, the mischief rule, the golden rule, the rule of harmonious construction, the rule of egestem generis, the rule of nocitur associis, the rule of ex verbius actus, the rule of expressio unius est exclusio alterius, the rule of contemporanea exposito est fortissimo in lege, and the rule of at res magis valeat quam pariet. So, I have given the meanings under the brackets for these Latin maxims. Try to pronounce it as the way it is. Okay. Coming to the first rule, the rule of literal or grammatical interpretation of a statute. So, the literal rule is nothing but the court has to interpret the statute in such a manner. It should not go deep inside the meaning and dig what is given by the lawmakers, what is given by the legislators to implement this statute. So, the plain meaning, what is the meaning and how we have to interpret to implement and in an effective manner is the literary meaning of that statute. So, here they have said first of all, try to look for the most literal or grammatical meaning of the word or the phrase. Only when such a meaning is given, an absurd result, then the court of law should look for some other rule of interpretation. So, the primary important thing is to make use of the literal or grammatical meaning of that provision or statute. So, we have certain case laws in which one of the case law is State of Kerala versus Mathai Varghese. In this, what this person has did, this accused person, he was counterfeiting the currency of USA, and he has been charged under the Indian penal codes. So this accused is saying that I have been counterfeiting the other currency and not Indian currency, and why should I be penalized by the Indian Indian codes and Indian penal codes? So this is a question of doubt arising. But the relevant sections of IPC, that is section 489A and 489B, says that counterfeiting the currency notes. The currency notes indicates any kind of currency notes, whether it is India, USA or any other country, bank notes, promissory notes, all these are involved. There is no mention that only Indian, if there is a forfeiting of the counterfeiting of these Indian currency notes, you will be penalized. It is not like that. It is the counterfeiting currency notes or bank notes is the act which is mentioned in section 489A of IPC. So in the similar way, the section 489B also, it using genuine forged or counterfeit currency notes or bank notes. So they didn't mention any kind of country, origin, nothing like that. So the Kerala High Court used the explanation clause attached with section 489A and held that it is abundantly made clear that the term currency note should not be prefixed with any other term, as it is not all necessary. So this is the thing the Kerala High Court has implemented with a plain law without going deep into the meaning. When we take the case of the second case law, Maqbul Hussain vs. State of Bombay, the very famous case law. This Maqbul Hussain, a citizen of India, he was carrying a lot of gold bars from Dubai and he has been seized by the customs authority. He has been seized under Sea Customs Act 1878 and Foreign Exchange Regulation Act 1947. This Maqbul Hussain, what he did, he contended that I have been in a contravention, that my fundamental rights are infringed, and Article 20 Clause 2, that I have been under double jeopardy. But this is not the case. Only the Sea Customs Act is only a provision which is taken, but he is charged only under the Foreign Exchange Regulation Act 1947 and he is not charged for double jeopardy. The Court of Law held that the authority created under the Sea Customs Act was not a court and hence any order of the said authority would not amount to prosecution. Hence the accused should be charged only under the Foreign Exchange Regulatory Act. There is another case law which defines the simple and plain meaning of the statute. In Ramavadar versus Assistant Sales Tax Officer, this Ramavadar is a trader of betel leaves. He said that I don't want to pay any sales tax. I am only selling these betel leaves. Betel leaves are nothing but like vegetables. But the Supreme Court took a view that simple meaning of the term vegetable indicated that a plant item should be consumed only after the cooking procedure. But the betel leaves are simply eaten like that. So this is a simple common decision of the sales tax authorities was correct and he was penalized for the tax. So such a simple concept. As such, we have come to the end of the video. Let me ask every time a riddle so that I want your enthusiasm and your encouragement in making more videos like this. The riddle is in this video. At the end of the video, please like and subscribe the channel for more interesting videos on these topics. Please comment and share. Thank you.